filtering out weak cases which would otherwise be tried in the Crown Court. So a mechanism has been created to save the time and money of the court, because a lot of people are required for the trial in the Crown Court. 12 jurors and judges, and it makes the trial very hectic and long, and it needs to be very efficient and effective. So it creates a lot of barriers for the Crown Court to deal with all of the cases. So Crown Court only tries to take or filter out the cases which need to be tried and get rid of the cases which are not of serious nature. A Crown Court trials are expensive, time consuming, and involve 12 jurors. A system has evolved for getting rid of cases which are doomed to failure before the case is listed for the trial. Where a case is sent to the Crown Court to be tried, the prosecution is required to serve its witness statements on the defense by a certain date. Once that is done, the defense will ask themselves whether the evidence discloses a case to answer. In other words, rather, if all these witnesses said to a jury rather what is in their statements, a jury could possibly convict on that evidence or not. If the defense feels that evidence does not disclose a case to the answer, it does not has a strong substance, it does not hold any evidentiary value, they can apply to the Crown Court judge to consider the prosecution witness statements, to see the substance to it, to see them in detail, that rather do they have any evidentiary value or not, whether they are on point or not. And if they are not, the Crown Court can dismiss the charges before the trial even starts, and this saves the time of Crown Court. And in this way, the Crown Court only deals with the cases that are of serious nature and do not waste the time and money of the court and jurors.